Good evening, everyone, and thank you for joining us for the third Family Education Night of the 2024-2025 school year. This is one session in a series of 6. My name is Kristen Parson, and I am the IEP liaison for Northstar's Career Center. I'd also like to introduce Holly Peel, who is the director of the Career Center. At the Career Center, we work with juniors, seniors, and young adults with disabilities to help them build career readiness skills they can use as they transition out of secondary education and enter the workforce. You can learn more about the different fields that we offer programming in on the Northstar, on the Career Center tab of Northstar's main website, or you can reach out to us directly via email, and we'll be sure to post our contact information in the chat here shortly. We are very excited to have attorney Matt Bellinger from BeneCounsel here with us tonight. BeneCounsel is a legal firm that assists families of individuals with disabilities with legal and financial planning. They work with families on everything from guardianships to applying for disability benefits to special needs planning. Tonight, Matt is going to be providing an overview of those decisions and processes. We at Northstar have been fortunate to work with Mr. Bellinger for quite some time, as he has represented several families and even partnered with our business technology program last fall to offer a few of our students a virtual internship. And it sounds like we'll be lucky enough to have a repeat of that this year. So without further ado, I'm going to turn it over to Matt, and the rest of us are going to turn off our cameras.
Hi, everyone. Little bit about my background, very short. 1986 graduate of the Naval Academy. I served in the Marine Corps for 8 years. Got out, was a logistics manager for a trucking company for 12 years. Decided that's not what I wanted to do with the rest of my life, so I went to law school. This is actually my third and final career. Graduated University of Richmond in 2008. Was doing mortgage-backed securities for Hunton and Williams downtown. And that was ground zero of the recession. So I found myself out of work, trying to figure out Medicaid and Medicaid waiver services for my daughter, who's on the autism spectrum. I threw my pen down and thought to myself that I'd have to quit your job and do this full time to figure it out. And that's when the light bulb went off. So like I said, my daughter is on the autism spectrum, so I am a parent of a child with a disability as well. She's 26, and what I would say to you to consider is that she can do things at 26 that I really never thought she'd be able to do at 18. So our children with disabilities, they have their challenges, but they continue to develop at their own pace. And so my daughter is an alumni from Northstar, both the school and the Career Center, and it was huge in turning her life around. It was pretty bad with public school. That experience was, well, enough said about that, but Northstar was wonderful. So what we're going to be talking about today is basically the kinds of things, the legal things that you need to be thinking about when your son or daughter is going to be turning 18. You spend so much of your time when they're young or when they're children, students, trying to figure out special education, trying to look at therapies and other things. And then all of a sudden, they reach 17 and a half, 18, and you're like, oh my gosh, there's all these other things we have to think about. And that's where I really try to help people. So, let's see. Some of the things that change when your son or daughter turns 18 is it gets really hard for you to do even routine things like medical appointments and even sometimes filling prescriptions, because your son or daughter, when they turn 18, are considered to be adults under the law, and they have not only the rights to make their own decisions, but they're expected to do a lot of things for themselves, and a lot of privacy laws snap into place, making it much more difficult for parents to continue doing things. I know when my son turned 18, get on the phone to make a medical appointment for him, had to get him on the phone to do it. He now does it himself, but my daughter still needs help. So we'll be talking about those kinds of things today. So it's the kinds of decisions at 18 that get a little more challenging, or educational decisions, medical decisions, and so forth. 18 is often the time where your son or daughter may become eligible for disability benefits too. It is possible for children to receive SSI, but most people, many, It's when their son or daughter's turning 18 that SSI starts coming into play. So we'll talk about all of that. So capacity isn't actually defined in the Virginia Code. It's incapacity that's defined, and it's in the guardianship section of the statute. But it's helpful to think about it in terms of whether or not a person can receive and evaluate information and make it decisions, effectively make decisions based on that. And it specifically says that bad decisions is not evidence or sufficient evidence of incapacity. And it's hard to kind of come up with scenarios that show the difference between bad decisions or poor judgment, because I know I've had lots of times where I've exhibited poor judgment and incapacity. But what we're really talking about is somebody that, under the guardianship statute at least, is incapacitated where they really can't make decisions. Not that they just need help or need assistance, but where they can't. So, and it's only because they can't process information sufficiently. So I start with alternatives to guardianship. Not only have I always done that, because as a parent, we go to all sorts of transition programs or groups, and you hear things. And you know, in fact, when I started working in this area as an attorney, I'm like, oh, I'm never doing a guardianship. Until then, you actually meet people that absolutely need a guardianship. So I've come around 180 degrees on that. But we look at alternatives to guardianship first, because guardianship's more restrictive. If person loses rights under a guardianship. And recently, well, actually, the last 5 years, the General Assembly has been making changes to the Virginia Code regarding guardianship, making it more difficult, adding more checks and balances. And one of those checks and balances is that you have to be able to say why less restrictive alternatives won't work. So that's where we start. It's the right thing to do, and we also need to from under the Virginia Code now too. So we're really talking about a power of attorney here. They can do a number of different things. There's a durable general power of attorney. Medical power of attorney is also known as an advanced directive in Virginia. But advanced directive also includes end of life decision making and wishes, and I don't include that in the documents I write for a young adult. I don't want to have that conversation with them. Plus, I don't think they're ready for that anyway. So what we're really doing is a medical power of attorney. There's a power of attorney for education. So the capacity to sign a power of attorney is also not defined under the Virginia Code, but it is in our case law. And really what it is that you have to be able to understand the authority that you're giving the other person. You don't have to be able to read the document and explain it all back. You don't have to have a long conversation about what an agent is and what's agency relationship and things like that. You just need to understand that the person signing it, the principal, needs to understand the authority that they're giving to their agent. And it's up to the attorney working with you or with their clients to determine whether or not their client has that capacity. I work solely with adult children with disabilities in their family, so I like to find that level of capacity whenever I can, whenever it makes sense. And if you ranked all the attorneys in the state as far as the easiest to the hardest, I'm somewhere at the top. Now, if there ever is an issue where somebody says, hey, I don't think they have capacity, I'm not going to accept this power of attorney, well, then the court would be the final decider on that. But I don't ever see that happening. I don't have that issue. I could absolutely see it happening when you're talking about elderly persons in mind, because the documents we're talking about here are the same kind of documents that you do, same kinds of powers of attorney and advanced directives that you do when you're doing your own estate planning. So we're appointing an agent to do something for you. But in the context of an 18-year-old, I think it's sufficient for them to want to have their parents or grandparents or cousins, whomever it may be, to act as their agent to do things for them. And I kind of think, I always get a chuckle when we have this conversation, because I always think that in the back of their mind, they're saying, this is crazy talk. You know, of course I want my mom to continue to make medical appointments for me. That's what moms are for. I mean, if you want me to sign a piece of paper saying they can do that, sure, I'll do that. But yeah, that's just weird. That's what I think what's going through their mind. So medical power of attorney is very useful. Again, lined up new doctors when they have to change from pediatrician to a general practitioner. You can make a medical appointments. You can fill prescriptions. Doctors can talk to you because it has a HIPAA release, and you can help make medical decisions. We use it with our daughter, and it works great. Durable general power of attorney is for like contracts and things of a financial nature or information forms, Medicaid applications or the annual form, Medicaid waiver service. When they start receiving services and you're figuring out how many attendant care hours and signing off on that, it allows you to do all of that. Very useful document, although we've never used it with our daughter because everything that we can do with it without her being there, we do with her being there, so she learns how to do it and experiences it. It's also a power of attorney for education, which is basically just for IEP meetings. It's for under the Individuals Disability Education Act, IEP meetings, and you can go to it and sign off on the IEP. Now, these documents don't take away a person's rights. They can still make their own decisions. They can still do things for themselves. And you'll find if you go with this route that you end up using them a little less every year, a little bit more as your son or daughter, a little less each year as your son or daughter starts doing a little more for themselves. And another alternative to guardianship, it's really more of an alternative to a conservatorship. We'll talk about that in a second, is being a representative payee with the Social Security Administration. So if a person, a young man or woman, doesn't have the capacity to sign a power of attorney, and in those cases, it's typically that they're minimally verbal or nonverbal, then guardianship is the only other alternative. It's also in some cases when a young man or woman who may have capacity to sign a power of attorney has really serious and severe medical issues that need the certainty that comes with a guardianship, or they have behavioral challenges or bipolar disorder or schizophrenia, that sometimes, even though they may have the capacity to sign a power of attorney, we sometimes will go with a guardianship. Depends really a lot on the situation and on the person. But so there are cases and time frames and situations, I would say, it's more of a situational thing, where we may still do a guardianship instead of a power of attorney. So guardianship is over the person, so to speak, and guardians make decisions, medical decisions, decisions about where to live, and educational decisions. Conservatorship is financial decisions. They're like flip sides of a coin, and the process is the same, but in a little bit we'll talk about how conservatorships are often not needed, even if we're doing a guardianship. So guardianship is a process in the local circuit court. It starts when you file a petition asking the judge to appoint guardian or co-guardian, so you can have more than one guardian at a time for the person. And you can also ask the judge to appoint a standby guardian. That's somebody that does nothing while the guardians are living, but would step into their shoes if something happens to them. If you are doing a guardianship, you don't have to ask for a standby guardian to be appointed right away. You can always add them at a later date. And in fact, I think many cases, you're almost always going to come back at a later date to add another standby guardian from like a younger generation, maybe a sibling or a cousin, because our children are likely going to outlive us. So if you're doing a guardianship, having a standby guardian appointed is nice. Nice to have, but not required. As part of the process, the judge will appoint another attorney, a guardian ad litem, whose job is to represent the person's best interest, not to be their attorney, but to represent their best interest. And their job then would be to meet with everyone, meet the ward or the respondent, in this case, the young man or woman, and look at the medical reports and report back to the judge. Does the person need a guardian? Are the proposed guardians suitable? And less restrictive alternatives, would they work in this case? I've only had that come up one time with a guardian ad litem, and I think I was probably pushing it a little bit much, but we were worried about some behavioral challenges. We ended up, in that case, withdrawing the petition, and we did powers of attorney. But that's what the guardian ad litem's job is. Now, I made a distinction saying that the guardian ad litem doesn't represent your son or daughter. They represent their best interests. So a person in a guardianship actually has the right to an attorney. If they want one, the judge will appoint one for them. And if they can't pay it, the state would pay for that attorney. They also have a right to a jury trial. That sounds strange. You're going to have a jury trial for a young man or woman, but the process is the same no matter if you're 18 or 85. So if I were to get a guardianship over my father, he could absolutely have his own attorney. We'd have my attorney. I might have attorney. The guardian ad litem be there. He'd have an attorney. And if any of my stepbrothers or my brother and sister had an issue with me being guardian, well, they could have an attorney too. So you can really see that it can be a very complex case in the right situation. Almost never for a young man or woman because it's with a lifelong disability, because those are really straightforward though. So there's a hearing in the matter, and once the judge signs the order, the guardians then have all the legal authority to continue making decisions for their son or daughter or for their family member even after they turn 18. Conservatorship, like I said, is over finances. It's the same process, but I don't typically recommend doing conservatorships, and there's a few reasons why. Is a young man or woman has not been working their entire life. They have no estate to manage, no reason to be a conservator. When they become eligible for SSI, you can become their representative payee. The Social Security Administration doesn't use guardianships or conservatorships or powers of attorney. It's a federal benefit. And what they do for a beneficiary that can't manage their own finances, they'll appoint a representative payee. That's somebody then that will be responsible for managing their disability benefit. And the other reason I don't like doing conservatorships, really don't like doing, is that it comes with reporting to the Commissioner of Accounts. So it's like being an endless probate with an initial inventory, and then accountings. Now those accountings can be moved every 3 years. They can be less expensive if the person's getting Medicaid. And some commissioners of accounts will waive those. It's just not worth adding in those extra fees and reports if you don't need the level of authority that comes with a conservatorship. The only time I do it is when somebody that can't, is under a guardianship already, and they get a direct inheritance or an injury settlement. And then we have to do a conservatorship to be able to move their money that they're just awarded to like a trust, a first party trust, to restore their eligibility. But as soon as I can get rid of the conservatorship, we do. I go back in and end the conservatorships. So don't do a lot. And that's really only primarily because I work with young adults with disabilities and their families. So recent changes to the Virginia Code. I talked about the one where guardian ad litem now have to report to the judge whether less restrictive alternatives will work. Judges are supposed to set a series of review hearings now. The first one's supposed to be a year later, and then every 3 years after that, or as the court may decide. That can be waived, and in most of my cases, the judge will waive those because it doesn't make a whole lot of sense to have a review hearing when it's parents for an adult child with a lifelong disability, and they recognize that. There's a process for restricting visitation. It's also a required visitation schedule. It's every 120 days. One of the visits has to be in person, at least one. Parents, though, that are guardians for their children, even if their child lives in a group home, they visit so many more times than is actually required. A lot of well, not a lot. I think that required visitation requirement is set up specifically for like attorneys that may be guardians for 20 or 30 people. Not even public guardians. They already had a visitation schedule requirement there. So, and there was one other change that, starting next year, once they had the program in place, guardians are supposed to now take a course, get some training. I don't know what that's going to look like. I don't know how involved they're going to have to be, but that's another recent change to Virginia code. And I actually would have to applaud our General Assembly for doing this. It's a pain in the butt, and I've gotten upset every time they've done it, and I push back. I can't push back, but I try to. It doesn't make a difference. But I really do think it's a good thing that they're adding in these more checks and balances and requirements, because from the state's point of view, they're taking away somebody's rights and they're giving it to somebody else. So what they're really doing is making sure that that's only happening when it absolutely is necessary. So duties of a guardian. Well, like the primary responsibility of a guardian is to be available to make decisions for a person. You don't have to live with them. You don't have to provide a primary caregiver. Just be available. So if they need, if they're at the doctor's office and the doctor wants to change their prescription, be available to make that decision. Obviously, check in on them, make sure everything's going well, and if it's not, you take action to fix it. But most of my clients still live with their son or daughter. So really the only additional duty that they have is there's an annual reporting fee, reporting form with a $5 fee. So report a guardian. The first one's due in 6 months after the guardianship hearing, and then it's annual, and it's really straightforward. Guardians are not liable for acts that the person may commit or do unless they're negligent. I can find no case law on that. My example for that is if I were a guardian for somebody and I took them to Costco and there was an issue, I'm not negligent. If I take them a second time, the same thing happens. Am I negligent? No. But you can see by the third, fourth, fifth time and the same thing happens, I think I might be negligent at that point for not recognizing that there's something about that particular location is causing an issue. Guardians are not required to expend their own personal funds for somebody. And the rest here you can read, but it's really just kind of limitations. If you move from one state, from Virginia to another state, there's a process for transferring it. General Assembly really would like guardians to continue to try to get the person to gain as much capacity as possible. So kind of talked about powers of attorney and guardianship. One thing is that to think about it, and if you just kind of pull back a little bit, look from a higher level, both result in a piece of paper that you're going to give to a third party that says, this is why I get to help or make the decision or do what I would like to do for the person. And neither route changes how you work with your children. You're still going to talk to them. You're still going to help them understand whatever the decision that may have to make, help them to understand as much as possible. Keep them involved in everything. Nothing changes really in how you work with your children. It's really, at the end of the day, we're getting something that we give to a third party, a doctor or a case manager or a school that says, or a bank that says, this is why I get to do what I want to do for my son or daughter. So there's a time for questions. If you have any that you've submitted to the chat, that would be good for us to review. And also, if you have a question on guardianship and powers of attorney, if you would send it in, that'd be great.
So I don't see any questions in the chat so far. That doesn't mean that they won't come. So thank you for going through that piece of your presentation. I know that with everything constantly changing, it's nice to have somebody who's versed in all of those changes, to stay on top of those. We do have a question. We have, are these documents geared towards special needs, or are they general power of attorneys?
So my powers of attorney are geared specifically for young men and women with disabilities. I took these templates my templates that I use for for adults, for um, parents or grandparents are different. They're much more detailed to cover a lot of the things that can happen. So we'll think about it, because I have a power of attorney and an advance directive. The level of financial management that I may need in the future, if I'm no longer able to do it for myself, let's say I have Alzheimer's and my son needs to take over, is a lot more significant than what a young man or woman at 18 may need. And I've also had a couple times where we get a little pushback from a pharmacist that says it doesn't say anything about pharmacy here. So what do? We just added it. Now it's there. A doctor that says, well, it doesn't say anything about this. We added it. I think there was even one with a durable power of attorney that said it doesn't say anything about finances. And I would argue in each of those cases that are covered, because it refers to powers that are in the Virginia Code, but it's much easier just to change the document, redo it for those 3 cases, and then add it to my template. So it's a lot of that where it's built up over time, just making it more specific to young men and women with disabilities.
So just covering more bases.
Yes.
Yeah. We have a couple other questions that came through. Are there resources available to assist with the cost of establishing guardianship / power of attorney?
Sort of. There is the annual IFSP funding for people that are families that are on the DD waiver wait list. It's $500. Their Commonwealth Community Trust has also a fund where sometimes I've had a community service board be able to access that. Sometimes a community service board will help. Our fees are lower, and I have started a nonprofit, Lighthouse Disability Law. We're not up and running yet, but that would be to help provide free services for low-income families in the same areas. William and Mary has a law clinic, William Law School, School of Law, where they do some free ones. There's a waiting list there, though. So, but no, unfortunately, there's not a whole lot of financial help for families in this area.
Great. How do we know if our child qualifies for SSI and government-funded aids? Can you speak more about those aids and what to consider? And I think that probably leads us right into our next section. So
The
that's
perfect segue
timing.
question.
Yeah, that's great. So I'll let
Disability
you
benefits.
continue on. Holly, did you have something you want to add before we get rolling?
I did. There was one other question in the chat. I just want to make sure we didn't skip it before we went on to the SSI
thank
topic. What is the time frame for getting the power of attorney? How long before the child turns 18 should we start that process?
That's an excellent question. So the earliest you can file a guardianship petition is 6 months prior to a person's 18th birthday. There's no difference in the process whether your son it's before or after their 18th birthday. Like I said, the process is set up really, in my opinion, for elderly persons. It's the same no matter if you're 18 or 85. For powers of attorney, you usually start a couple months in advance. We write them, draft them, send them out for review, but we have to wait until after the young man or woman turns 18 for them to have the legal capacity to sign them. Starting about 6 months prior to your son or daughter's 18th birthday is fine. If you start the month before, that's fine too. If you start 6 months after, that's typically fine too. I have often have families come to me when their son or daughter's 21, 22, 23. They've gotten that far just on the basis of being appointed as an authorized representative by the community service board. Their doctor works with them because they know who they are. And the power of I'm their father. How dare you not let me make decisions for them? But eventually they run into an issue where you have to do a guardianship or powers of attorney. So best case is start about 6 months prior. But if you can't for some reason, don't worry about it. It's not something to stress over. That said, I'm gonna say this and knock on wood that I don't have any cases like this. The only time that I will jump through hoops to get a guardianship in place as soon as possible is when we're talking about serious mental health issues with a person that's receiving inpatient mental health treatment and they're turning 18. Because they have the right at 18 to make their own decisions and they can leave. And so I haven't had that happen in now like 6 years, and I would hope that I don't have any more cases like that. All right, disability benefits. So we're talking about three really here: SSI, supplemental security income; SSDI, which is Social Security Disability Insurance. So unfortunate that those acronyms are so similar, because they really are two different benefits. They also have the same application process, but we'll parse through those. And then, oh gosh, I thought I had fixed this. It's not childhood disability benefit anymore. It's the disabled adult child benefit. It's better named now. We'll also talk about Medicare and Medicaid real quick. So SSI, supplemental security income, is for persons with low income and low assets who have a disability, who are blind or over the age 65. Now, it's typically for young adults, it's the only monetary limitation that makes any is an issue, is the countable resource limit of $2,000 because they're not working. So as long as they have less than $2,000 in countable resources, they'll meet the financial limitations. And from there, it's really all about medical records. Doctors, not case managers, but therapists, facilities where they've been treating, medications they've been taking. The more medical records, the better, in my opinion. It just makes it easier. And applying for SSI, you can do it in a couple different ways. You can go online and apply online. That might be the best way. For me, it seems like it's the easiest way, because you get a code and you can go in and you fill that out in sections, and then you can go back in and fill a little bit more and go back in. And they count, the Social Security Administration counts when you started it, not when you actually finish it, as the date of application. Or you can call your local office and make an appointment. They've been doing most of those by phone now. And so if you do the appointment route, my recommendation would be go to their website, get all the information that you need as far as doctors' names and addresses and phone numbers, because they'll be filling out the application with you. The time to apply for it is after your son or daughter turns 18. Until they turn 18, your income and assets are deemed to be theirs, which makes most children ineligible for SSI. And parental deeming of income and assets, though, ends when your child turns 18. So apply after the age of 18. It can't be paid out to them prior to the age of 18 anyway, if you're, unless you are also low income and have low assets. So there's no good reason to apply before they turn 18. Start after they turn 18. Takes the Social Security Administration now about 6 months to come to a decision. And when they do, and you find that your child is eligible, there'll be a back benefit for those months. So you're not going to be losing any money. You might hear some horror stories about how they deny most everybody. For young adults with lifelong disabilities, they actually do a really good job. And it's not often where I hear from a client that their son or daughter has been denied. There is an appeal process if they are. First is a reconsideration, and then if the reconsideration comes back negative, then you go administrative law judge hearing. And that's really not a topic for today's discussion, but the takeaway from the appeals process is that eventually, if you have to go to an administrative law judge hearing, I absolutely recommend getting an attorney at that point. They can't charge a fee unless they win, and their fees are capped as a percentage of the back benefit that would be awarded when they win. So, and it's really helpful. I used to do SSA appeals. I don't like working with the Social Security Administration. It's like working with a black hole. Information goes in and nothing comes out, and it can be very frustrating. But there are attorneys that can navigate that pretty well. The maximum benefit in 2025, this is the new number, is $967 a month. It's meant to pay for living arrangements. It used to be living arrangements and food, but they dropped the food part of that. So it's meant to pay for living arrangements. And that's significant because if your son or daughter is receiving SSI and they're living in your home and they're not paying their fair share for living arrangements, that's a type of unearned income called in-kind support and maintenance. And it will reduce their SSI benefit by 1/3. The way you get them their full benefit is to charge them for their fair share of living arrangements. So your rent or mortgage for the month plus gas, electric, water, sewer, if you're paying for that, divide that by the number of people living in your home, and that will be your son or daughter's fair share. Hopefully that number comes out to someplace between like $600 to $800. That's typical. And so charging them for their fair share of living arrangements does two things. One is it gets them their full benefit, and the second is that it's their largest monthly drain on their account each month, keeping it under $2,000 because they still have that $2,000 accountable resource limit. And so by charging them rent, you are keeping them under that limit. And in a way, if you think about it, we'll get a little later, we'll talk about Medicaid, but Medicaid, when a person passes and they receive Medicaid, there's a state recovery. That's not likely going to be a very fundamentally challenging thing for most persons with lifelong disabilities like autism and so forth, because they are always going to be under that $2,000 accountable resource limit to maintain their eligibility for benefits. So what we're kind of doing, though, by charging them for their fair share of living arrangements is we're kind of laundering the Medicaid payback clause off of that, because once it's your money, it's your money. There's no Medicaid payback, and you can use it to do whatever you want with it. Of course, you're going to continue to support your son or daughter, and that's what the money is really going for. But anyway, charging them for their fair share of living arrangements is a good thing. And you'll notice that I've said fair share of living arrangements every time, and I've resisted the urge to call it rent. You can call it rent. It doesn't matter really what we call it, but it really is fair share of living arrangements, because the next question I typically get is, if I'm charging them rent, does it count as income to me? My answer to that is a qualified no, because it's not rent. You're not in the business of renting out your house or rooms in your house. Your son or daughter is just paying for their fair share of living arrangements. If you Google it, you'll come up with all sorts of answers. And that's because there's no case law and there's no IRS revenue ruling on it. And another thing that I have is there would be, if the Social Security Administration, if the IRS felt that that was rent to parents, they could absolutely find out who is getting paid, who is the representative for a son or representative payee for a son or daughter who's also charging room and board. They could get that information from the Social Security Administration, and they don't. So it is not income to the parents. But I said it was a qualified no. I could see situations where it would be. You do rent your house out or a room out in your house to another boarder. Well, then it may more likely that it could be rent. Or you have rental properties and they're living in one of their rental properties. Well, then it might be rent. So for the most part, for most families, though, it's not income. So a little information here about later on when your son or daughter is receiving SSI and they're working. So earned income. Unearned income reduces their SSI on a dollar-for-dollar basis. So if they get $100 from Aunt Betty's $100 to them technically would reduce their SSI for that month by $100. But when they're working, it will reduce their SSI, but not on a dollar-for-dollar basis. My back of the envelope calculation for that is they'll lose about 40 cents of SSI for every dollar they earn. And the takeaway from this is that they will always make more money working, even though their SSI is reduced. Always make more money working. And that's because there's work incentives that come into play. First of all, the first $20 don't count. There's a general income exclusion. The next 65 dollars doesn't count because there's a earned income exclusion. There are some other work incentives like the impairment related work expenses and things like that that can further reduce the what counts. But then they take half of the what's left. So like I said, person receiving SSI who's working will always make more money. And I think I have a chart coming up that shows it. I'll switch over to that. And so like if you take a look at this, SSI only, this is SSI and part-time work. Always make more money. We'll get back to that chart in a second. So that's SSI. SSI is not is administered by the Social Security Administration, but it's not part of the Social Security Act, even though it's got the same first two letters, SS. It's actually paid through by the general federal budget. Easier for our politicians to put all sorts of stupid little requirements and so forth on it. SSDI, Social Security Disability Insurance. Now, this is part of the Social Security Act. It has the same disability requirements as SSI, and it's the same application process. So actually, when you're first applying for SSI for your son or daughter, and you click on that button to do it online, and it says apply for disability benefits, you're actually applying for both SSI and SSDI. And the first letter you typically get back is saying they're not eligible for Social Security benefits because they don't have a work record, they don't have sufficient work credits. And that can often cause a little bit of anxiety. It's a poorly worded letter because it doesn't say anything about supplemental security income, just talking about Social Security benefits. But yeah, that's the first letter. SSDI is what you get if you've been working long enough, you've earned enough work credits, and when you work, we pay our payroll taxes, and one of those payroll taxes is for Social Security, OASDI, Old Age Survivor Disability Insurance. It's all kind of lumped together. That's what we also will eventually draw Social Security from, retirement benefits. But if you're injured and you can't work and you meet the requirements, then you can get SSDI off of your own work record. The amount of work credits that you need to get SSDI depends on how long you're working and how old you are. I need to be working the last 10 years, and I've got the highest number of credits requirement because I'm 60 and I've been working a long time. A young adult who's just starting out can qualify with just 6 credits earned in like a 3-year period. So another benefit to working is eventually your son or daughter will be able to draw SSDI off of their own work record. Does it give them additional money? No, actually it doesn't, because for SSI purposes, the SSDI counts as unearned income and it reduces it on a dollar for dollar basis. It results in actually a $20 increase in benefits because of the general income exclusion. But it's better because SSDI doesn't have all those stupid little rules that SSI has. And eventually it is absolutely possible, if your son or daughter continues to work, for their SSDI to replace their SSI completely. And again, that's not a bad thing. Go to that chart real quick, show what it kind of looks like. When they first start getting their SSDI, that's the SSDI portion. This is the part-time work and SSI. The more that the SSDI portion grows, the less the SSI becomes. And the final disability benefit that we want to talk about is the disabled adult child benefit. This is also a Social Security benefit. It's for adult children who are deemed to be disabled before the age of 22 when a parent retires and starts drawing Social Security, or that parent becomes disabled and starts drawing SSDI themselves, or the parent passes away. Let's go with the retirement one. That's the better one. When the parent retires, their son or daughter can draw a disability benefit off of the parent's work record. It's often referred to as SSDI off of a parent's work record, and that's kind of what it is, but it's really the disabled adult child benefit. The child has to be disabled before the age of 22 and unmarried. And the numbers vary as far as how much that disabled adult child benefit is going to be based on the parent's work history. I have clients who receive both SSI and the disabled adult child benefit because the parent had a minimal work history. So they get a little SSI, a little disabled adult child benefit. But I have also a number that receive $1,400 to $1,800 a month. So it wipes SSI out. If they're still getting SSI at that point, it wipes it out. Counts as unearned income for SSI purposes and wipes it out, but that's fine. More. And it doesn't have the stupid little rules that SSI has. So you don't have to worry about reporting income anymore. It has no countable resource limit, but we're getting ahead of ourselves a little bit there. And it's much harder for our politicians to change it. I believe Social Security, there needs some changes need to happen to make sure that it continues to be fully funded into our futures. But it's more difficult. So it's not something that our politicians tinker with. They'll eventually get to it. That's my opinion. And so what it looks like at that point is the disabled adult child benefit. And if your child is working, they can continue to have earned income, and that's when their income will be the highest. Now, if your child is not able to work, that's okay. They'll get SSI until they get the disabled adult child benefit. So I'm going to skip the questions at this point because I think for all the disability benefits, we should include both Medicaid and Medicare. And then we'll go to questions. So Medicaid is like SSI. It's like a companion to SSI. It's for persons that have low income and low assets, that are disabled, but that have a disability, that are blind or over the age of 65. It has the same countable resource limit as SSI, $2,000. Now, Medicaid is the joint federal and state program, and it's administered by each state. If your son or daughter isn't getting Medicaid as a child, the process basically is to apply for SSI. Once they're approved for SSI in Virginia, you'll need to do a separate Medicaid application for them. We're one of the handful of states that has a few different requirements for Medicaid that causes us to have a separate application process. But if your son or daughter is approved for SSI, they'll get Medicaid. It's not an issue. Medicaid also includes, and this really isn't part of the presentation, but Medicaid waiver services. So Medicaid waiver services is part of the Medicaid long-term care plan, which also includes nursing home care. But instead of having to go to a nursing home to get services, the waiver services provides those services in the community to help your son or daughter with a disability live and work in the community as independently as possible. And that is perhaps really should be part of the program. One of the most important benefits that your son or daughter will use. You may need it when they're young, if they are disabled, if their challenges are sufficient. But eventually, the Medicaid waiver services is going to be very important to helping, figure out some things, perhaps like what are their long-term living arrangements are going to be. And you have attendant care and respite care. And these are things it's very important, Medicaid waiver services. Community Service Board is the gatekeeper for that. Chesterfield Mental Health, and Enrico Mental Health, Richmond Behavioral Health. And Medicare, again, why do we have all these programs that have similar names? Medicare is not the same as Medicaid. It's more like the SSDI portion. Medicare is something that we pay for with our payroll taxes. It's a federal health insurance program that, like I said, we pay for through our payroll taxes. And the reason it's on here is that your son or daughter can get Medicare a couple different ways. First, they can get it if they're working and they start receiving their SSDI off of their own work record. They get Medicare after 2 years. The other way they can get it is when you retire and start drawing Social Security benefits yourself, retirement benefits, and your son or daughter becomes eligible for the disabled adult child benefit, then they get Medicare too. So eventually, for many of my clients, the long-term medical insurance for them is going to be Medicare. It is possible to have Medicare and Medicaid at the same time. And there are actually more and more programs, or not program. If you talk to an insurance agent at that point, they can help you pick what's the right, like, it's not Medigap either, but there are plans that are specifically designed for dual eligible individuals, Medicare and Medicaid, that can increase their benefits. So, and if you're in the military, and you're able to get TRICARE for life for your son or daughter, then you could have 3 medical insurance programs. You'd have Medicare, TRICARE, and Medicaid. Medicaid is always the payer of last resort. However, Medicaid is still important to have because it also includes the Medicaid waiver services, like we were talking about. And if you ever needed, your son or daughter in their elder years ever needed long-term nursing care, Medicaid does it. And Medicaid pay for other things too, like durable medical equipment and modifications to a home for a person that may be in a wheelchair and need to modify their bathroom for it. So Medicaid does pay for some things that Medicare does not pay for. All right, that was a lot. It's like drinking from a fire hose, but I'm ready for any questions that you may have.
Thanks, Matt. I don't see any questions in the chat yet, but there might be some posted. I think you probably said this, but just for me, for my clarification, are there any of those, when you talk about SSI, SSDI, Medicaid, Medicare, are there any that in Virginia, if you qualify for one, then you automatically are qualified for the other ones? Or is it just an application process for each one?
Okay. For SSI, it's an application process, SSDI application process, but that's the same process. So once approved for SSI, if your son or daughter is working, Social Security Administration will eventually catch the switch over to SSDI.
Okay.
My recommendation would be to check with them after like 3 years of working to find out, hey, I understand they can perhaps draw SSDI off of their work record. Can we look at the work credits and see what that's like to help spur them make that change? Same thing with the disabled adult child benefit. When you're retiring and start figuring out your own Social Security payments, when you're going to take it and all that, that's also the time to inquire about the disabled adult child benefit. There's no separate application for it. Your child becomes eligible for it when you retire, just kind of spurring the Social Security Administration to make the change sooner rather than later. They'll eventually catch it, and then they will, oh gosh, they're doing better now. They are trying to do better. But I've had, in the past where son or daughter, the person's son or daughter is getting SSI, they retire, become eligible for disabled adult child benefit, but the Social Security Administration doesn't catch it on their own for like 6 or 7 months. And then there's a bunch of letters kind of coming at you, and one saying, oh, they're no longer eligible for SSI, here's how much you owe us back. And then there's another one, here, you're eligible for this new disability benefit, and here we owe you this amount.
And here's
it's
your
just
back pay.
Yeah,
Right.
exactly. And here's your back pay. And it's, if anything that you can do to lessen that confusion is good.
While
Medicaid,
you're on
yeah.
The SSDI and the DAC, we had a question that came through. If disabled adults get SSDI plus the DAC, are there requirements to charge them a fair share for living arrangement costs?
If they're getting SSDI off their own work record or the disabled adult child benefit off of a parent's work record, there is no requirement to charge them for room and board. But I recommend you continue to do that because they still have a $2,000 countable resource limit, specifically for the Medicaid waiver services. That's really the one we're going to be protecting, but Medicaid as well. And that charging them for room and board helps keep them under that $2,000 limit. If you're really adverse to doing that, what you can do, and this is a segue into the next section we'll cover really briefly, is put that money that they're paying to you as rent in a separate account in your name, invest it, put a beneficiary designation on it then, so that when you die, it goes into their special needs trust, so they get the money back. That would be my recommendation. Because now that has no Medicaid payback clause to it. If you need it for them while you're living, it's still there. And if you don't need it for them while you're living, it goes into their trust after you pass. So
it's just kind of a way of investing
yes.
in the future. Yeah,
Yeah.
that's great. Next question, if parents are working when the child turns 18 and have health insurance, would you not need Medicare or Medicaid until the health insurance term for the children covered expires? So I guess when they're no longer considered a dependent.
Good question. Yes. So you can continue to carry your son or daughter on your employer provided or your private insurance until they turn 26. And actually, in that hierarchy of medical benefits, private insurance, Medicare, TRICARE, Medicaid. Do they still need Medicaid at that time? And the answer is yes. I would apply for Medicaid for them after they're approved for SSI. They may eventually need it, but it's also required to keep their eligibility for Medicaid waiver services. When they become eligible for Medicare, that's the time to really take a long, hard look to see if you still need to carry them on your insurance. Medicare is good insurance. All of us as seniors rely on it, and it's accepted by almost all doctors. So, and it'll become their long-term medical insurance. So if you're still carrying your son or daughter on your private insurance at that point, then that's a time to perhaps drop that and let them go on to just using their Medicare.
It just works better.
Yeah.
Yeah.
Now, one thing on that too is I've been pleasantly surprised at how many insurance policies through employer provided insurance allow a parent to continue carrying a child with a disability past the age of 26. So if you still need it at that point, check with HR and see about what you need to do, if possible, to continue carrying your son or daughter on your insurance.
Great. This one is a clarification, which may have been partly my fault with my question, but to clarify, we should apply for SSI first and then apply for Medicaid services once approved for SSI. Is that correct?
Yes. Apply for SSI first and then apply for Medicaid if you need to. Now, that said, if your son or daughter is already receiving Medicaid waiver services, then they've got Medicaid. So it's just the SSI application. Well, I'll make a distinction. There's two different application processes one for Medicaid, which is just the medical payment plan for going to the doctor and things like that, and Medicaid waiver services. Now, waiver, that's the word in Medicaid waiver services. What's waived? One of the things that's waived is parental deeming of income and assets. So your son or daughter, you can actually apply for them for Medicaid waiver services at any time. Your income and assets aren't deemed to be theirs. There's a waiting list for the DD waiver, and it's substantially long, although, again, kudos to the General Assembly. They doubled or more than doubled the funding for it this past year, to the extent where they had to put in a language that says, basically gives service providers enough time to gear up for the number of people that'll be getting services. So I would say if your son or daughter is under the age of 18 and you haven't applied for Medicaid waiver services, to go ahead and do so. Contact your local community service board, get the ball rolling. Do they come off the waiting list any sooner? No. It's typically what I see is that when your son or daughter ages out of special education, about the time their school ends, that's when they typically come off the waiting list and start receiving services, especially if they need things like going perhaps day support and things like that. Although you can be on the waiting list a little longer, but getting on the list is still a good thing.
And it sounds like, I'll jump ahead and then I'll go back to a couple other questions, but it sounds like that's kind of the answer to this question. My autistic child is 16 and we have good private insurance. Should I still apply for Medicaid waiver? And it sounds like yes, to be a part of that wait list and to be a part of receiving those Medicaid waiver services.
Yeah, so Medicaid waiver services, we're talking about attendant care, respite care, active case management, somebody then, if they were living more independently, to check in to make sure they're taking their medications. You'll probably thinking to yourself, well, I do all that for my child now, but eventually you may not be in that position to do that. So that's why waiver services are so important. The Arc of Virginia has an excellent website that lists all the waivers and all the services that can be accessed under that. One of like extended job coaching, transportation services. There's quite a bit of good things there. So and like I said, Medicaid waiver services, it's not for medical insurance, it's not Medicare or Medicaid, but it's services that help your child live and work as independently as possible. And my personal opinion is that somebody said it the other day, one of my clients, the value of that is much greater than the value I think you get financially from like SSI or SSDI.
That makes sense. All right, going back to a couple other questions. If your adult child works, what is the income limit to receive benefits?
Okay. So to be disabled for Social Security Administration regulations, you have to be incapable of performing substantial gainful activity, SGA, substantial gainful activity. It's a defined term. This is the same for SSI and SSDI. One of the definitions of SGA is whether or not a person's making more than 2025 numbers, $1,620 a month. If you make more than $1,620 a month, you are probably not disabled under the Social Security Administration regulations. Higher if you're blind. And so I would say that that is the number that you should work with, $1,620 a month. Now, that said, I typically recommend that once your son or daughter starts making about $1,000 a month, just because it's an easier number to remember, that you take a look at it and see what other work incentives may apply to help them work as much as possible and maintain their benefits. So there is a particular work incentive called Ticket to Work. And if you use your ticket, you get associated with an employment network with a work incentive practitioner who gets paid to give you advice as far as how do you keep your benefits and work as much as possible. And that's free to you. It's free to the person with the disability or receiving disability benefits. And they can certainly help you navigate it at that point. I think there's a sweet spot, though, for most of my clients, and that is working part-time and, if possible, getting that SSDI off of their own work record, getting their Medicare, having a disability benefit, having the earned income, and eventually getting that disabled adult child benefit off of a parent's work record. Now, is it absolutely possible for our sons and daughters to work full-time and get benefits from their employer and not have to rely on disability benefits? Absolutely. And if they can do that, that's wonderful. And that work incentive practitioner with the Ticket to Work program can really help with that.
Great. Okay. The last question that I see for you is, do Able Now accounts have any effect on SSI or other public benefits?
Good. Another question where we can segue into the next one. And how long am I supposed to go today?
So our session is scheduled till 6:30.
Oh, okay.
And then probably maybe stop a few minutes before that, just so we can open it up for non-recorded questions. Holly, did you have a question before we segued?
I did. I'm popping in before the segue again. I have great timing tonight, I think. Thank you so much for explaining the Ticket to Work benefits, because I think more people need to know about that. I just wanted to chime in and remind families that that is also accessible through DARS benefits. So as folks are working with DARS and then get connected, the Department of Aging and Rehabilitation Services as a part of pursuing employment services, when they're connected with an employment service organization, those financial advisors, which are called WISA for short, the work incentive advisors, are available through that route as well. So you don't have to worry about that being yet another thing you have to pursue separately. When you're referred to that ESO, that can be something you request. And finally, I just wanted to mention something that's great and positive, which is that DARS no longer requires that a young person is eligible for SSI for job coaching benefits to be free. If you didn't know that was ever a requirement, don't worry about it. If you did participate in these trainings, let's say more than 6 months ago, that was one of the pieces of this very intricate puzzle of applying for benefits that needed to be in place, or else there was a financial eligibility a requirement that families would need to meet. But that SSI requirement is no longer in place, and those job coaching services are available to families. So good news, we're moving in the right direction. I think that's refreshing. And thank you for all of the other updates about how the General Assembly has been making some positive provisions. And I'm going to let the segue happen now. So thank you for letting me interject.
You're welcome. That's good news, actually. My daughter's had a number of job coaches, and I have employees with job coaches. It's a wonderful help. So I'll skip a couple slides down to get to ABLE accounts, because that's what the question was about, and then I'll go back. So ABLE accounts, 529A accounts. Money in an ABLE account does not count as a resource for SSI and Medicaid waiver service eligibility. Does not count against that $2,000 countable resource limit. They were created a number of years ago. Virginia was the first state to go ahead and implement it. Yay, Virginia. Again, kudos to the General Assembly. They were, I think, originally intended to try to find a less expensive alternative to special needs trust, but they didn't get there. They still are an important piece of the puzzle, though, or can be. Like I said, money in an ABLE account doesn't count as a resource. It can be invested and it grows tax-free. If you put some of your own money in it, you can get a small state tax deduction. Although I'm not sure it can be worth that if you take a look at it. But it does have, I'm going to skip ahead a little bit though, because I started talking about putting your money in it. It's a great place for your son or daughter's money. It's not such a great place for your money because it does have a Medicaid payback clause, meaning any money left in an ABLE account when the beneficiary passes is supposed to go back to the state to reimburse for Medicaid expenses. Now, General Assembly, again, doing good things, said that they're not going to do that to the extent federal law allows, but federal law still requires it. So my best guess is that if there's $6,000 to $8,000 to $10,000 in it when a beneficiary passes, that the state is not going to try to recover that money, but it can have up to $100,000 in it before it starts counting as a resource. So there is a limit. You can't have any more than 100,000. If it's over 100,000, it counts as a resource. So if there's $80,000 or $90,000 in it, I do think the state's gonna try to recover that money because it's worth their effort. So where does it fit in the puzzle? It fits great as a super savings account for your son or daughter's money. So when we're talking about them getting SSI and then working, they'll always make more money working, even though you're charging them for rent. You might find where all their accounts gets close to $2,000. That's a great time to start having them pay for more of their own expenses, like their cell phone and so forth. But if you run out of expenses for them to cover of their own expenses, you can move money from their accounts into their ABLE account and save it for larger expenses down the road. So it really is a great place, a great place for your son or daughter's money, and some of your own money if you wanted to put it in there. If you have a 529B college savings fund that may be earmarked for your child and they don't use it all, you can use it yourself. You can use it for any other family members. So 529B funds, even though it may be earmarked for a particular family member, doesn't count as a resource, first of all, for SSI or Medicaid for your son or daughter, because it's not theirs, it's yours. And any family member can use it. But you can also convert it from the 529B into a 529A. And so that's something that you can do with it if they're not going to end up using it for college or using some of it for higher education. You can move the rest of it into a 529A ABLE account for them, and then use it for other things, even living arrangements. So place for Virginia's ABLE account is ablenow.com. So $2,000 countable resource limit is something we've talked about a number of times. SSI, Medicaid, and Medicaid waiver services. Eventually, your son or daughter may not get SSI anymore, so we don't have to worry about that. But we do really need to worry about the Medicaid and Medicaid, especially the Medicaid waiver services. So the way that you leave an inheritance to them without messing up their eligibility for disability benefits is to create a third-party special needs trust. Third party is in anybody's money except your son or daughter's. So any family member can put money into a third-party trust for your son or daughter, or for a beneficiary that's getting SSI and Medicaid that we're trying to protect those eligibility for those benefits. While you're living, third-party trust typically sits unfunded, is an empty bucket. Protecting your son or daughter's eligibility for benefits, way it's funded typically is when you pass away through your will and beneficiary designations on like life insurance, IRAs, and 401ks. So we've got a trust, third-party trust for my daughter, and my will and beneficiary designations all say everything to my wife. She's my primary beneficiary. But if she's no longer living, then half to my son is typically developing and the other half to my daughter's trust. So it never is my daughter's. It goes around her, it goes into the trust. The trust is a separate legal entity managed by the trustee. That's why it doesn't count against her eligibility for benefits. And then the successor trustees use that money to pay for things that her disability benefits aren't paying for. Third-party trust has no Medicaid payback clause, so any money left in the trust when my daughter passes away would go to her kids if she has any. I'm not sure she will, but if she has kids, it'll go to her kids. And if not, then it goes to her brother and his family. So it stays in the family. It goes to whomever it says in the trust agreement. Third-party trusts can own any kind of investment that a person can own. It can have multiple accounts, different banks. It can have a brokerage account. Can buy stocks, bonds, mutual funds, can also own real estate. So sometimes a third-party trust can play a role in what you determine your son or daughter's long-term living arrangements are going to be. We're thinking about leaving our house to our daughter's trust so that she can continue living in the house. We also could perhaps purchase a condo that my wife and I own while we're living. Put a transfer on death deed in place so that when we pass, it'll go into her trust and then she can continue living there. So it could play a role in that regards as well. Eventually, trusts will pay their own taxes, but that's not something you need to worry about. The successor trustee will do that. I would recommend to any successor trustee that they hire an accountant, that they use an investment advisor unless they like doing that kind of thing themselves, and get some legal advice when they think they need it. A first-party special needs trust actually is what I use to restore somebody's eligibility for Medicaid, Medicaid waiver services, and SSI if they get a direct inheritance or an injury settlement. This does have a Medicaid payback clause. So this is one we want to try to avoid having to do. And it's funded then with the individual's money. So it used to be that to qualify for Medicaid long-term nursing care, that you'd have to spend your assets down to under $2,000, and then you'd qualify and Medicaid would start paying for that long-term nursing care. The Social Security Act was amended to allow for these kinds of trusts to be created, a first-party special needs trust. If you're under the age of 65 and you need Medicaid long-term nursing care, you can create a first-party trust, put your money into it, qualify for the long-term nursing care. The money in the trust is still available for use on your behalf, but it does have a Medicaid payback clause. That's the trade-off, is that any money left in the trust when the beneficiary passes, has to go back to the state to reimburse her for Medicaid expenses, and I absolutely expect that the state would do that. We recover the money in the trust. So this is the kind of trust we don't want to spend any more time on. This is the one we want to avoid doing. Have I done them? Yes, absolutely. Sometimes you have to. And then the whole goal is to invest the money in the first party trust, but use it during the beneficiary's lifetime so that if there is any Medicaid payback, it's minimal. All right, so pooled special needs trust. This isn't a different kind of trust. It's just a different way of doing it. There are two nonprofit entities in the state of Virginia, Arc of Northern Virginia and Commonwealth Community Trust, that run pooled trusts. And they do the same exact things as the third party trust and the first party trust. They have similar products, except that you create a sub-account under their master trust agreement, and the resources under management by the ARC or by Commonwealth Community Trust are pooled by the trustee for investment purposes. The pooled trusts are more designed to be less expensive again for than what attorneys charge to create the standalone trust that I was talking about. And what I found though is that where it really is useful is for small families that don't have a whole lot of candidates to be successor trustees. So in my trust for my daughter, for example, I think it's my brother, my wife and I are the initial trustees, and it's my brother and brother-in-law. We still have to change the trust, do an amendment to appoint a successor trustee from a younger generation. And luckily we have family members that I think will be able to do that. If not, for some reason, my whole plan then is to what's called decant the money that's currently in her trust, because her parents-in-law, her grandparents, my parents-in-law left some money to her, and it's in the trust. Decant it and do a pooled trust. So the benefit of a pooled trust is you don't have to name a successor trustee, because they take care of that. They are the trust administrator and they have a trustee. And but for all intents and purposes, they function just like the third party trust and the first party trust I talked about. The ARC calls it a self-settled trust for the first party trust, and a family funded trust, which is also a really good name for that third party trust. And what happens to the money in a pooled trust when the beneficiary passes is the same. First party trust, it goes back to the state. The self-settled trust goes back to the state to reimburse her for Medicaid expenditures. And the family funded trust or third party trust, you can designate who gets it, who's the residual beneficiary. Talked about able accounts, and I think that brings us to the end of the presentation. If anybody has a question specific to trust, if you would please put it in the chat. And then once we're done with that, I think we end the recorded presentation. And if you have more personal questions, we can answer a few of those.
Yeah, great. Okay, so we have one question in the chat. For the first party special needs trust, if you move the individual's money there, does Medicaid have a 5-year look back that would negatively impact eligibility for Medicaid?
So Medicaid Waiver Services does have a 5-year look back. One of the ways that you can move beneficiaries' money within that 5-year span and get them eligible is to put it into a first party trust. So this is exactly what, so if I was presented with somebody calling me saying their son, daughter turned 18, they have $40,000 in the bank, and they need to qualify. And all right, so I would say with $40,000, my go-to would be able account. Let's make it more simple. If they called me today and said that they have $36,000 in the bank, my go-to would be open an able account now, put $19,000 in it this year and $19,000 in next year, and that's covered. They'll meet the financial eligibility requirements. Yes, there's a 5-year look back, but when they do the look back, they'll see that it isn't a proper account, an able account or a first party trust. And it's proper because both of those have the Medicaid payback clause. So Medicaid requirements will be satisfied. Now, if it was 100,000, then I would say we do a first party trust, because you can't wait. You may not be able to wait that long for the $19,000 contribution each year to the ABLE account, plus 100,000 you'd be pushing up towards the limit of the ABLE account. So yes, Medicaid has a look back, but if they look back and see it's been moved to the proper kind of account, then it's not an issue.
Okay, great. Thank you. I don't see any other questions in the chat. So thank you so much again for your time. It's always so appreciative, your expertise and the way that you break everything down for our families. I know that I learn something every time that we have a session. And since there are no more questions, I'm going to go ahead and end the recording. And participants, you can remember that the slide deck and other resources will be available on our Family Education Nights page through Northstar's website, and they will also be sent to you later on this week. For those of you who are still with us live, you are welcome to stay on after the recording ends to ask more personal questions. And we hope to see you next month for our next session, which is on post-secondary education programs.